Hello everyone, welcome to the online session of Social Science. Today we will continue with the same topic, that is judiciary. In our previous video, we have seen some topics like what is judiciary, what are the various functions of judiciary, what is the meaning of independent judiciary, what is the structure of various courts, what are different types of laws. So in this video, we will study in detail about Supreme Court, High Courts, Subordinate Courts and some other topics like Lok Adalats, PIL, etc. So let's start. The Supreme Court of India. Composition. As we have seen in the previous video also, that the Supreme Court is the apex court of India. It is at New Delhi. The President appoints the Chief Justice and other judges. The President must consult other judges of the Supreme Court and the judges of the High Court in the appointment of the Chief Justice. He must consult the Chief Justice of the Supreme Court before appointing any judge to the court. Now, what are the qualifications required to be a judge of Supreme Court? For appointment as the judge of the Supreme Court, one must have the following qualifications. He or she must be a citizen of India. He or she must be a judge of the High Court for 5 years, or she must have served as an advocate in the High Court for at least 10 years, or she must have been a distinguished jurist in the opinion of the President. The Chief Justice and other judges hold office till the age of 65 years. Now we will see the various jurisdictions of the Supreme Court. The jurisdiction of the Supreme Court is the area within which the court can extend its authority. Original jurisdiction. It means the authority to hear certain cases for the first time. The Supreme Court has original jurisdiction over disputes like between the Government of India and one or more states, between two or more states, between Government of India and some states on one side and one or more states on the other side. Appellate jurisdiction. Appellate jurisdiction means that the case has already been decided by a lower court and then the case is brought before the Supreme Court. The Supreme Court entertains appeals against all the state high courts. Thus, the Supreme Court is the final court that decides appeals. Advisory jurisdiction. The Supreme Court also has advisory function. The President can consult the Supreme Court on certain matters. If the President thinks that an important legal question has come up or is likely to come up, he can take the advice of the Supreme Court. The Supreme Court will give its opinion, which is not binding on the President. The Supreme Court is also the court of record. All the decisions made by the Supreme Court or all the proceedings of the Supreme Court are kept as record. They can be used for reference either by the High Court or the advocates. The decisions made by the Supreme Court are binding on all other courts in India. The Supreme Court maintains all the previous records of the cases. All the judgments of the Supreme Court are duly recorded and printed. The lower courts treat these judgments as laws. Now we will study the High Courts. India has 28 states and 8 union territories. The Constitution of India provides for a High Court in each state, but there can be a common High Court for 2 or more states and union territories. Composition. The High Court consists of a Chief Justice and other judges as appointed by the President in consultation with the Governor of the state and Chief Justice of India. In the appointment of other judges of the High Court, the President consults the Chief Justice of High Court also. The Constitution does not fix maximum number of judges for a High Court. Now, qualifications. The Chief Justice and the other judges must have the following qualifications. He/she must be a citizen of India. He/she must have held a judicial office for minimum 10 years, or he/she must have worked as an advocate continuously for a period of 10 years, or he/she must be a distinguished jurist in the opinion of the President. Each High Court is also a court of record. Its judgments are referred to by all the lower courts just like laws. A High Court supervises the lower courts in the state as well. Now we will see subordinate courts. All the states in our country are divided into districts. Every district has got many kinds of courts which decide both civil and criminal cases. In each district, the highest court is that of the district and session judge. Additional district judges are also appointed if the quantity of work is heavier and one court finds it difficult to cope with it. The highest district court for trying criminal cases is that of the session judge. The criminal cases can also be heard by magistrates, but if their judgments do not favor a party, he may file an appeal in the district court, and if the latter also fails to satisfy the party, it may go in for an appeal to the High Court of the state. Apart from this, there are courts of sub-judges that try civil cases involving property. There are small cause courts in big towns that decide cases up to a certain nominal amount that changes from time to time. There are village courts that decide cases of movable property. Now, Lok Adalats. In order to provide quick, affordable, and speedy justice to the poor and downtrodden, the system of Lok Adalats was provided in 1985. The movement was part of the strategy to relieve heavy burden on the courts with pending cases. The aim was to give relief to the litigants who wanted to get justice. There was a serious problem of overcrowding in courts. If there is a permanent forum to which cases may be referred to, the load can be taken off the court. Lok Adalats were established by the government to settle disputes through compromise and conciliation. The Lok Adalats is presided over by a retired or sitting judicial officer as the chairman, with other members, usually a lawyer or a social worker. There is no court fee. Main condition of the Lok Adalat is that both parties in dispute should agree for a settlement. The decision of the Lok Adalat is binding on the parties. No appeal can be made against the decision of the Lok Adalat. Lok Adalats have helped the people to get justice, and disputes can be settled quickly and free of cost. Now, here a question arises. Does everyone have access to the courts? Although in principle, any citizen of the country can approach the courts if he or she believes that his or her rights have been violated. But in practice, access to courts has always been difficult for a vast majority of the poor in India. This is because our legal procedure takes a lot of time and money and requires lots of paperwork as well. In order to increase access to justice, the Supreme Court in the early 1980s introduced a legal mechanism called PIL, or Public Interest Litigation. According to this, any individual or organization can file a PIL in the High Court or the Supreme Court on behalf of those whose rights have been violated. The legal process is very simple. Even a letter or telegram addressed to the Supreme Court or the High Court can be treated as a PIL. So, in this way, the judiciary is playing a very significant, very important role in democratic India. It serves as a check on the powers of the executive and the legislature. It also protects the fundamental rights of citizens. That is why people all over the country have faith in judiciary. Thank you.